Welcome to the State of Nevada General Information Training on Workers' Compensation for Nevada Employers. This training provides basic information for Nevada employers about workers' compensation and specific requirements expected of them. In this training, participants will learn about the mission statement of the Workers' Compensation section. We are the regulatory agency charged with implementing the statutes and regulations relating to workers' compensation insurance. You will learn what workers' compensation is and how it relates to you as an employer. You will be familiar with the critical workers' compensation forms, the posting requirements, and other responsibilities of an employer. After this, we will break down the basic functions of the different units comprising the workers' compensation section. We will also show you some helpful information to become an effective and compliant employer in the state of Nevada, such as proper worker classification and some myths and realities about workers' compensation. The mission statement of the state of Nevada's Workers' Compensation section, also referred to as the WCS, is to impartially serve the interests of Nevada employers and employees by providing assistance, information, and a fair and consistent regulatory structure focused on ensuring the timely and accurate delivery of workers' compensation benefits for Nevada injured workers, and to ensure employers comply with the mandatory coverage provisions of the statutes. Let's begin the training. Workers' compensation is a no-fault insurance program in the state of Nevada, which provides benefits to employees who are injured on the job and protection to employers who have provided coverage at the time of injury. Unless excluded by statute, it is mandatory for an employer who has one or more employees to provide workers' compensation insurance coverage. Because Nevada has exclusive remedy, the injured workers' benefits are set forth in the statutes. Employers who provide coverage for their employees at the time of injury are protected from any additional damages claimed by their employees as a result of an injury on the job. This protection is established when the injured employee opts to receive workers' compensation benefits. Unlike other employee benefits, where an employee waits for some period to accrue benefits, an employee's workers' compensation benefits start the moment the employee steps on the employer's premises on his or her first day of work. Employers may contract with a private insurance carrier authorized to operate in the state of Nevada, be self-insured, or join a self-insured group. Employers who do not provide workers' compensation will be charged with an administrative fine up to $15,000, may be issued premium penalties, may be ordered to close business until insurance has been obtained, and will be held financially responsible for all costs arising from a work-related injury. In addition, the uninsured employer may be subject to a criminal penalty for claims resulting in substantial bodily harm or death under NRS 616D-200 and NAC 616D-345. All employers who employ one or more employees are required to have workers' comp insurance. It is the employer's responsibility to secure workers' compensation insurance with a Nevada licensed carrier unless they choose to be self-insured. A self-insured employer can manage their own work injuries, or they can join a self-insured group. An employee injured on the job has the right to seek medical treatment if injured. The insurance company shall contract with an accredited healthcare provider to provide appropriate medical treatment to injured workers. Healthcare providers include hospitals, emergency departments, clinics, therapy places, diagnostic facilities, pharmacies, and other medical centers as authorized by the insurance company. The injured worker shall not pay any amount related to his or her injury. The healthcare provider also cannot send the bill to the injured worker. NRS 616C.135 states, the healthcare provider may not charge the patient for any treatment related to the industrial injury or occupational disease, but must charge the insurer. The workers' compensation section assists injured workers in getting their benefits and regulates employers, insurance companies, and healthcare providers to ensure compliance with mandatory coverage provisions. On the next few slides, we will go over the forms that employers need to be familiar with regarding workers' compensation. The D1 form briefly describes the employee's rights and benefits as an injured worker. The state of Nevada requires all Nevada employers to provide certain information in relation to workers' comp. Form D1 is the brief description of whether the employer is required to obtain industrial insurance and whether a person is a covered employee. It also describes your rights and benefits if you are injured on the job or have an occupational disease. This poster must be displayed in a common area, usually a break room or a hallway where most employees can see it. This form is usually provided by the insurance carrier or the third-party administrator, but anyone can access this form on the WCS website. The poster shall be at least 11 inches by 17 inches in size. The bottom part of the form, which contains the insurer, contact person, and other contact information regarding the insurer, as well as the information for the healthcare provider, shall be provided to assist injured workers where to go in the event of a work injury. The D22 form is the notice to employees about their option to use tips in calculating their wages. The Form D22 notifies employees of their right to report tips, if they choose to, for purposes of calculating compensation to determine workers' comp benefits. The injured worker may submit to his employer an employee's declaration of election of report tips, Form D23. The employee must make his election separately for each pay period before the end of the next pay period. The declaration may not be amended. Upon receipt of such notice, the employer shall make a copy of each report which the employee has filed with the employer to report the amount of his tips to the United States Internal Revenue Service or employee's declaration of election to report tips. They can submit the copy to its workers' compensation insurer upon request, or if the employer is self-insured or an association of self-insured public or private employers, retain the copy for his records. If the employer is not self-insured, pay the insurer the premiums for the reported tips at the same rate as he pays on regular wages. An employee who elects to report his tips is not eligible to receive increased compensation based on those tips until 3 months after his employer receives the employee's declaration of election to report tips. The C1 form is the form required by the state of Nevada to report work injury to employers. The C1 form is the notice of injury or occupational disease. This is the official form injured workers shall use to report a work-related injury to their employer. The form can be downloaded from the WCS website. The employer must keep copies of the C1 form readily available for employees to use. This form must be completed within 7 days of the accident. It must be signed both by the injured worker and the supervisor as a representative of the employer. Signing the C1 form does not mean acceptance of liability on the part of the employer. It is only an acknowledgement that the employer was informed of the alleged work injury. The C1 form must be provided by the insured to the employer. However, it is in the best interest of the employer to maintain a sufficient supply of blank C1 forms, as the onus of providing C1 forms to employees are on the employer. Employers must keep completed C1 forms for at least 3 years. Always use the latest version of this form. The C4 form, Employees Claim for Compensation form. The C4 form, also known as the Employee's Claim for Compensation or Report of Initial Treatment form, is a state-mandated form used to document the initial medical treatment for an injured worker. The upper portion of the C4 form is completed and signed by the injured worker. The lower half is completed by the healthcare provider. An injured worker has 90 days to seek medical treatment from the date of injury. The healthcare provider has 3 working days from the date of treatment to transmit the C4 form to the correct insurance company or third-party administrator, also referred to as a TPA, and to the employer. The healthcare provider shall maintain a sufficient supply of C4 forms. The form can be downloaded from the WCS website. NRS 616C.0407 provides for a $1,000 administrative fine for violation of subsection 1, which requires a treating physician, chiropractic physician, physician assistant, or advanced practice registered nurse to complete the form within 3 working days after first providing treatment. Always use the latest version of this form. The C3 form is the employer's report of industrial injury or occupational disease. The C3 form is required of employers to complete upon receipt of a C4 form either from a TPA, the healthcare provider, or the injured worker. The employer must complete and sign this form and submit it to the insurance company or TPA within 6 working days of receipt of a C4 form. The administrator may impose an administrative fine of not more than $1,000 for each violation of this provision. Always use the latest version of this form. The D8 form is the employer's wage verification form. The D8 form is the employer's certification of the injured worker's wages for the purposes of calculating workers' compensation benefits. This form must be completed when the employer receives a C4 form certifying that the injured worker will be off work for 5 days or more. The employer must fill out a D8 form and transmit it to the insurer or TPA within 6 working days of the receipt of the C4 form. It is the responsibility of the employer to provide the following information to the employees. Regardless of their status as full-time, part-time, or per diem, contract employees may also be covered under the employer's insurance company. First, employers should inform their employees of their existing policies and procedures in reporting a work injury, including where to find the forms such as the C1 and C4 forms. The complete name of the employer as well as the name of the DBA if doing business as a different name. The employer should also inform the employee of their office address and phone number. Provide the name of the workers' comp insurance carrier and contact information as well as the name of the TPA if they have one. Where to go in case of an emergency for medical treatment. Provide the name and address of the clinic where employees involved in an industrial accident or illness can seek medical treatment. The name of the managed care organization, MCO if available, who will take care of the medical treatment of their injured workers. Provide the C1 form and countersign it as proof of acknowledgement that the injured worker notified them of the work injury. The accommodation process if light duty is available. Although we talked about the employer's responsibility to provide workers' comp benefits to its injured workers, the first and most important obligation of any employer is to provide a safe work environment for employees. Employers must comply with all OSHA safety standards. This includes making sure that anything that can potentially injure the employee is minimalized if not eliminated, providing personal protective equipment or PPE whenever necessary, providing safety information and safety training in every situation where the risk of injury may occur. All Nevada employers having at least one employee must secure coverage with a Nevada licensed carrier. Many carriers contract with the TPA to manage their workers' comp claims. Please make sure you are familiar with these relationships. Employers must fill out a C3 form or employer's report of industrial injury or occupational disease within 6 working days after the receipt of a C4 form and submit the same to the insurer or TPA. Report any accidents resulting in fatality or fatalities to Nevada OSHA within 8 hours of incident. Report within 24 hours to Nevada OSHA any accidents resulting in inpatient hospitalization, amputation of a body part, or loss of an eye. To report an incident to Nevada OSHA, call 702-486-9020 for Southern Nevada employers or 775-688-3700 for Northern Nevada employers. Insurers or TPAs have 30 days after accident notification or 30 days after receipt of the C4 form to accept or deny the claim and notify the claimant or claimant's representative of a determination under NRS 616C.065. They also commence payment of benefits on the claim if the claim was accepted. If the claim was denied, they shall also notify the claimant or claimant's rep and DIR of denial. The insurer's notification must be documented with a certificate of mailing. What type of workers' compensation benefits are employees entitled to? Nevada injured workers may be entitled to medical treatment. This includes all clinical consultations, referrals, diagnostic tests, prescription, and therapy visits. They may also be entitled to lost time compensation as payment for temporary total disability, TTD, and or temporary partial disability, TPD, if an injured worker was off work as ordered by a doctor as a result of an industrial accident for 5 consecutive days, or if the injured worker was off work for 5 days or more within a 20-day period, he may be entitled to TTD or TPD benefits. Permanent partial disability or PPD benefits may be obtained after a permanent partial disability evaluation by a Nevada rating physician. If the injured worker sustained a permanent disability rendering him unable to return to productive work, he may be entitled to PTD or permanent total disability benefit. The injured worker may also be sent to vocational rehabilitation if needed. Dependents may also receive death benefits. Lastly, the injured worker may file a claim for other claims-related benefits or expenses such as mileage. Must an injured worker accept the offer of a light-duty job? An injured worker who rejects a light-duty offer made in accordance with NRS 616C.475 and NAC 616C.583 risks the discontinuation of temporary total disability compensation. Are undocumented alien workers covered under Nevada's workers' comp statutes? Yes. According to NRS 616A.105, employee and worker are used interchangeably and mean every person in the service of an employer, whether lawfully or unlawfully employed, including aliens. However, undocumented alien workers are not eligible for vocational rehabilitation. The Workers' Compensation Section is part of the Division of Industrial Relations, which is a part of the Nevada Department of Business and Industry. The Division of Industrial Relations has several sections including Nevada OSHA, the Safety Consultation and Training Section or SCATS, the Mechanical Compliance Section, and the Mine Safety and Training Section. The Workers' Compensation Section, or WCS, is composed of 5 major units who serve the constituents of the state of Nevada: the Medical Unit, the Employer Compliance Unit or Enforcement Unit, the Audit Unit, the Education, Research, and Analysis Unit, and the Insurance Compliance Unit. The Medical Unit assists in verifying insurance coverage for employers. The medical unit helps healthcare providers identify the correct insurance companies so they can send the C4 form to them in a timely manner. There is a separate presentation for the coverage verification service and C4 form training on our website. The medical unit also processes D35 forms. The D35 form is the request for a rotating physician or chiropractic physician used to evaluate an injured worker's permanent partial disability, PPD. There is a separate online training for the D35 process for insurance companies and TPAs. The medical unit maintains the treating and rating panels of workers' comp physicians and chiropractic physicians. Application forms and other instructions about the treating and rating panels can be found on the WCS website. The medical unit also investigates medical bill appeals from healthcare providers to hold insurance companies responsible for paying the medical benefits of the injured worker. The medical unit investigates possible C4 violations by healthcare providers. And lastly, the medical unit investigates complaints from healthcare providers, insurers, TPAs, employers, and injured employees as well. The Enforcement Unit, also known as ECU, or Employer Compliance Unit, is responsible for ensuring employers comply with the mandatory coverage provisions of the Nevada Industrial Insurance Act. Compliance audit investigators conduct employer site visits, and the employer must provide evidence of coverage in compliance with NRS 616A.495. If an employer fails to provide proof of coverage or maintain coverage for workers' compensation, then the business operations could be subject to closure in accordance with NRS 616D.110. The enforcement unit also investigates uninsured employer claims and makes recommendations to the uninsured employer claim account for uninsured injury claims. The injured worker may elect to complete an employee election for compensation for uninsured employers, Form D-16, and employees claim for compensation for uninsured employers, D-17. It may be determined that the uninsured employer is liable and must cover the cost of the treatment, including all workers' comp benefits owed the injured worker. If an employer is found to have no coverage on the date of injury or there is a lapse of coverage, administrative fines, premium penalties, and closure of the business can result. In addition, referrals are made to the Nevada Attorney General's Workers' Compensation Fraud Unit for an investigation. The audit unit conducts audits of insurance carriers at least every 5 years. They also investigate complaints filed by injured workers against employers, healthcare providers, insurers, and TPAs. The audit unit also addresses injured workers' questions and concerns via email, phone calls, and walk-ins. The audit unit also reviews and makes recommendations to the Division of Insurance on TPA applications. The Education, Research, and Analysis Unit is responsible for educational outreach to our different stakeholders. They also manage the WCS website and the WCS Help Desk. The annual Workers' Compensation Educational Conference draws the biggest crowd of workers' comp players in the state of Nevada. They manage the claims indexing process. They process debt collection for unpaid fines and penalties issued by the workers' comp section. They compile data submitted by insurers and TPAs, such as the Annual Claims Activity Report and the Occupational Disease Claims Report. The Education, Research, and Analysis Unit also manages the CARD system and provides support to CARD's users. Insurer Compliance Unit conducts investigations of complaints that could result in a benefit penalty. They also investigate complaints concerning compliance with the hearings officer's orders or decisions from the appeals officer. The Employer Compliance Unit makes uninsured employer investigation recommendations to the Uninsured Claims Coordinator. The Subsequent Injury Account is an incentive program for employers. Nevada employers may be entitled to reimbursement upon request for injuries sustained by their employee who reported a previous injury from a former employer. You may visit the WCS website for more information about this program. Insurers and TPAs may file and be entitled to cost of living adjustment, COLA, reimbursements for benefits due the injured worker or their surviving spouse. Failing to secure and maintain a workers' compensation policy for employees could result in an administrative fine up to $15,000. Uninsured employers may be required to pay a premium penalty for the time the employer was uninsured. They will be held financially responsible for all costs relating to an uninsured claim. There is also a possibility of criminal prosecution from the Attorney General's office for operating without workers' compensation insurance coverage. Employer misclassification of workers is a growing problem. It can happen intentionally or unintentionally. Worker misclassification occurs when employers misclassify their employees as independent contractors in order to eliminate the employer-employee relationship. This is illegal in the state of Nevada. A 1099 or contract does not always eliminate the employer-employee relationship. Employers must examine their employment relationships before deeming their employees as independent contractors. Generally, employer-employee relationship exists when these four elements exist: the selection and engagement of the employee, the payment of wages, the power of dismissal, and the power to control the employee's conduct. Review the contract and consult an attorney when necessary to make sure you are classifying your employees properly. NRS 616B.603 pertains to independent enterprises and should be considered to determine if you could be deemed an employer under this provision. In order to not be deemed the employer under the independent enterprise exemption, you must not be in the same trade, business, profession, or occupation as the person or business with whom you contract, and workers' compensation coverage is always required unless the person or business with whom you contract with meets the independent enterprise statute. Incorrectly deeming employees as independent contractors can lead to serious consequences. Myths and realities about workers' compensation. Family and/or part-time employees do not require coverage. This is false. The reality is that workers' comp coverage is required under both circumstances. What if I just work for myself and I am the only employee of my company? In Nevada, owners may elect not to cover themselves and must complete a D-43 form. If the employer has at least one employee, workers' comp coverage is required. The subcontractors that I hire should have their own coverage, so I won't worry about workers' compensation insurance. Wrong. The reality is if you are a licensed contractor, you should know that you may be determined to be the employer of independent contractors, subcontractors, and their employees for purposes of providing workers' compensation insurance coverage. If an employee of a subcontractor or an independent contractor has a work-related injury and the employer has not secured industrial insurance, the principal contractor will be responsible for the actual cost of the claim plus administrative fees. For more information on Nevada's workers' compensation, please visit our website at dir.nv.gov/WCS/home. Click on the blue banner under Employer Compliance and find resources regarding workers' compensation. You can reach the workers' compensation section at the addresses and phone numbers listed below. Thank you for watching this video. Please check out our website for more workers' compensation related training videos. Have a wonderful day and stay safe, Nevada.